Hey everyone, this is Cole Boling with the Boling Group at Keller Williams, One Legacy Partners in Topeka. In partnership with my wife, Jamie, we are going through the real estate contract, and today we are on page 6. So we're going to get started here, and starting right at the top, we have home warranty. So what is a home warranty? A lot of people don't understand them. A lot of people like them. A lot of people don't like them. Either way, here's what we know. A home warranty covers you in the event that like a mechanical defect or something, like an air conditioner goes out, a hot water heater, appliance of some kind. You pay a company $400, $500, $600 for a 1-year policy. You have like a $75 to $100 deductible per occurrence, and those warranties will potentially cover issues that may arise after you close on the property. We would, if you are interested in buying one of those, we do determine up front who's going to order it, what's the date on it, is it the buyer and seller paying for it, who's the home warranty company, what's the cost, and what is the deductible. If you do not want a home warranty, you would initial the box down below declining an offer that has been offered to you, and you are declining it. Number 14, the real estate brokerage relationships. As part of all real estate license, we have to disclose who we are upfront to a client in terms of our partnership with you. We are either designated agents, sellers agents, transaction brokers, buyers agents, things like that. So what this section is it determines who the listing agent is and what their affiliation is to the listing, which would be the seller, and the buying, which would be the buyer. The selling agent is the buyer. In this, we would list the name of the agent. So you would be like Cole Boling, works at Keller Williams Realty. It would be on there. And then I may be the designated buyer's agent, or I may be the designated listing agent. We always check one of the boxes. If it's if I'm representing you and you're buying a for sale by owner, then we would have for sale by owner on the top. There would be no designated agency, and it would just be the selling agent. If it was reversed and a buyer came unrepresented to the transaction to purchase one of our listings, we would be designated seller's agent on both. Buyer and seller do acknowledge that the real estate licensees involved in this transaction may be functioning as an agent of the seller, agent of the buyer, or transaction broker. A transaction broker is basically a non-biased realtor who is not advising in any financial capacity to the transaction, which the only time that we would typically become a transaction broker would be if we are the listing agent and one of our buyers that we are under contract with becomes wants to buy one of our listings. The seller can allow us to become a transaction broker. The seller does have the right to tell us no, and they want another agent to represent the buyer, because we do know financial information, and it just is one of those things that we can do. And this is how we keep ourselves from being inside of an illegal situation, which would be called dual agency. Information given by the buyer to an agent for the seller will be disclosed to the seller. So anything that we hear about the buyer, any financial information, anything that is deemed beneficial to the seller, we are legally obligated to tell you as the listing agent. Information given to the seller, information given by the seller to an agent for the buyer will be disclosed to the buyer. Same thing. We represent you in the transaction. We have fiduciary responsibility to you as the client. All right, moving on now to number 15. Number 15 just basically says existing contracts. If we know, for instance, that there is another real estate contract that is going to be voided soon, and we're going to take that over, they may be a contingency, they may have a contingent contract in place, and we know we're going to come in and trump that contingency. We're going to put on here when that will be null and void, effective 5 p.m. today, or whatever the date is. We'll put that right there in that. Time is of the essence. If the buyer fails to comply with any of the terms of this contract shall, at the opinion of the seller, be null and void, and all rights of the buyer shall be terminated. All monies paid and improvements made hereunder shall be retained by the seller as rent or liquidated damages for said default by the buyer. In such event, seller shall be entitled to possession of said real estate, free of all rights, title, interest of buyer, and all parties shall be released from all further liability hereunder. If the seller does not exercise this option to cancel contract, the seller may exercise any other legal rights and remedies available to the seller under Kansas law. Basically what this says is you need to get things done in the timeframes of the contract. the dates on the contract, and you need to do it with a sense of urgency. Signatures done quickly, returned very quickly. Anytime a signature is out and floating in the world and not returned, it opens up the contract to being voided, especially during negotiations. So it is in the best interest of all parties to get everybody's signatures and initials and changes and dates and inspections and everything in a timely manner. Then we have number 17. Back in 2015, this became really popular, which was the use of electronic signatures. We now pretty much conduct almost all of our business via electronic signatures. We use a third-party company that does a data encrypted signature, which we can pretty much validate anywhere it was signed at. So what this says is the buyer and seller agree that the transaction may be conducted through electronic means according to the Kansas Uniform Electronic Transaction Act. An electronic record means a record created, generated, sent, communicated, received, or stored by any electric means. An electronic signature means that the electronic sound, symbols, processes attached to or logically associated with the record and executed or adopted by the people with the intent to sign the record. No real estate licensee in Kansas shall, unless authorized to do so by duly executive power of attorney, sign or initial any written or electronic contractual agreements on behalf of the party in this contract. Basically, we as agents cannot sign on your behalf in handwritten form or digitally. And last but not least, don't forget to initial the bottom of each page, seller and buyer, because you don't want to open yourself up to a contract getting voided. Have a nice day. Once again, this is Cole Boling with the Boling Group at Keller Williams, One Legacy Partners in Topeka, and we're here for all of your real estate needs.